Following the Civil Rights Act and Education PowerPoint is the segregation and discrimination. We'll go through a number of cases and laws, including historical perspectives, that will allow us to focus in on that which is important in this area. There are many pieces of discrimination that are not being covered in this section. However, in general, I think you'll find a good deal of information. We'll now go and talk about burden of proof in discrimination cases. The first case involves a claim of discrimination by a police officer against his employer. Think of it as a teacher against a principal or a superintendent. The officer claimed that he has been subjected to a less favorable treatment by this employer arising from a dispute over his travel expenses and a failure for him to secure promotion. He alleged that the reason for this treatment was because he had previously brought a claim of discrimination against the employer and was therefore being victimized, which is a category of discrimination. The result for what was found to be an absence of clear-cut evidence is a two-stage test for establishing discrimination, which would be central to not only this case but any case of discrimination. First, the claimant must establish that the case on its face amounts to discrimination. That's known as a prima facie case. If he's able to do so, then the burden of proof must shift to the respondent or the employer. The second stage, who will then have to show that it did not discriminate against the claimant or the employee. A simple explanation for the allegedly discriminatory conduct is hardly enough. It must be based by evidence. What do you think the results of the case was? There's a number of different ways to look at it. Now let's take a look at some historical perspectives. In 1897, the doctrine of separate but equal was established in the case of Plessy versus Ferguson. State laws from that time forward reinforced this concept in schools and all types of accommodations, public accommodations, particularly in the South. Based upon the 14th Amendment, Justice Henry Brown said, the object of the 14th Amendment was undoubtedly to enforce the absolute equality of the two races before the law, but in the nature of things, it could not have been intended to abolish distinctions based upon color or to enforce social as distinguished from political equality, or a commingling of the two races upon terms unsatisfactory to either. We now move forward to 1954 and the case of Brown versus the Board of Education, which was rendered in May of that year. The Supreme Court's opinion granted that it might be possible with segregation to achieve equality of tangible factors, things that money can buy, but the court rejected the idea that separate but equal, or that laws maintaining segregation, could provide equal protection under the Constitution. Further stating, to separate them, referring to black children, from others of similar age and qualifications, solely because of their race, generates a feeling of inferiority as to their status in the community that may affect their hearts and minds in a way unlikely ever to be undone. The Brown case addressed not only the equality of resources, but the hearts and minds of children, which was the very first time that the Supreme Court had addressed a case in that manner. I also want to bring to your attention several civil rights cases. The Civil Rights Act of 64 and 68, Bradley versus Milliken 1 and 2, which is the Detroit desegregation plan that was overruled by the Supreme Court and required the state to fund remedial and compensatory educational programs. The War on Poverty, Federal Head Start during the term of Lyndon Johnson, Title I of the Elementary and Secondary Act of 1965, which was a major motivational focus of Title I to reduce racial inequalities. Title I also changed the focus of funding by funding supportive services for students of all grade levels rather than only elementary students. In 1951 and 52, 5 district courts in 5 cases from 4 different states Kansas, Delaware, South Carolina, Virginia, and the District of Columbia ruled on the same issue. Was separate but equal still constitutional? And you notice the cases: Brown versus the Board of Ed, Briggs versus Elliott, Davis versus the County School Board, Gebhardt versus Belton, and Bowling versus Sharp. All very significant to this change of the philosophy of Brown. In 1957, Governor Orville Faubus ordered the Arkansas National Guard not to permit 9 African American students to attend Little Rock, Arkansas Central High School. This is the first event where a President of the United States sent U.S. Army troops in to end the conflict. It is one of the most significant historical events of the 1950s. The following Civil Rights Acts, some of which you've already been exposed to in the previous PowerPoint, apply to education. Title VI of the Civil Rights Act of 1964 prohibits discrimination on the basis of race, color, and national origin. Title VII of the same Civil Rights Act prohibits employment practices that discriminate on the grounds of race, sex, religion, national origin. Title IX of the Educational Amendments of 1972 prohibit discrimination on the basis of sex in educational programs. Section 504 of the Rehabilitation Act of 1973 prohibits discrimination on the basis of disability, both for student and teacher or employee. Title II of the Americans with Disabilities Act of 1990 prohibits discrimination on the basis of disability. Back to Title IX. Title IX allows for local educational agencies to establish single-sex elementary or secondary schools as long as they are not vocational schools, and this is not permitted in coeducational schools. If a single-sex school or class is established, then comparable courses, services, and facilities must be permitted for excluded students. The exceptions, of course, include contact sports, chorus, portions of classes dealing with human sexuality, and voluntary participation is permitted for students who are pregnant. Law versus Nichols was a significant case in California which requires, by its findings, that school districts take affirmative steps to help limited English proficient students overcome language barriers so that they can participate meaningfully in each school district's program. This was a case where Chinese students in San Francisco sued the San Francisco schools over not providing equal access to education. The civil rights requirements for student disabilities comes under Section 504 and Title II. Students with disabilities enrolled in public schools are entitled to a free and appropriate education. The IDEA, or Individuals with Disabilities Act, requires that students with a disability must be educated with non-disabled students to the maximum extent appropriate for the disabled students. The following cases challenge or affirmed desegregation plans or orders that were of major concern in the 1960s primarily and 70s, but began in 1954 with the Brown versus Board of Ed decision. Swan versus the Charlotte-Mecklenburg Board of Education, Green versus the County School Board of New Kent County, Jenkins versus Missouri, Freeman versus Pitts, and the Board of Education versus Dowell. I would encourage you to look at these cases as you learn more about desegregation. The next 3 sites have to do with Milliken versus Bradley, which was a case of consideration whether a district court, as part of a desegregation decree, could order compensatory or remedial education for programs for school children who have been subject to past acts of de jure segregation, and whether that was consistent with the 11th Amendment. And can the federal court require state officials found responsible for constitutional violations to bear part of the cost of those programs? And as you read through the slides, you may want to do a little more research on Milliken versus Bradley, which was a significant case in the 1970s. In Indiana, under Civil Rights Law 910, Indiana Administrative Code 3-3-1, there are rules for prohibiting discrimination, not making reasonable accommodations, retaliating and coercion, alcohol and drugs, drug testing, and smoking. I would encourage you to look in your state for the civil rights laws that are applicable. The last two slides have to do with important questions that impact every administrator. Must principals be selected on a non-discriminatory basis? Can teachers be transferred to promote desegregation? And this will be an interesting answer. Must an employee prove intentional acts by the employer to prove discrimination? Can schools pay men more than women? Are there remedies against or available if school districts retaliated against employees who make claims of sex discrimination or harassment? Can gender be a relevant factor in the selection of a school counselor? Are teachers protected against sexual harassment? Is same-sex sexual harassment illegal under Title VII? Must boys and girls have equal access to school sports under Title IX? I would encourage you to look at a small textbook called Teachers in the Law by Allen and Bacon. You will find the answers to these and many other questions having to do with discrimination, although there are many sites on the web that would answer them as well. And I'll certainly be happy to, at the end of the course, answer those questions if any of the students inquire. That concludes the section on discrimination and desegregation and those legal issues that are involved.